Good afternoon. Welcome to the Appellate Division First Department. Oral arguments for today, January 22. We have 6.5 hours of argument time requested. While it is arguably warmer in here than it is outside, I'm sure you can find other places as warm and more relaxing than the courtroom. So to that end, please only ask for the time that you actually need in order to get out the salient points of your arguments. Please keep in mind that we have read your briefs. We are fully familiar with your arguments. Also, please note that the time that is given we're not really wedded to that time if the members of the panel have additional questions to ask you, we will certainly do so. People v. Michael Lard.
Yes, Your Honor. I request 5 and 2.
424. Castanovic versus Finch apartment.
Can I have 6 and 2, please?
524. Matter of David F. That matter is submitted. Sola versus Harlem Urban Development.
Your Honors, appellant request 6 and 2. Request 5, Your Honor.
525. Empanada Fresco versus 1 BK Street Corporation.
Good afternoon, Your Honor. Appellant's request 6 and 2.
5252. People v. Gideon Godsent. There are two appeals. They will be called together.
Yes, request 6 and 2 on the trial appeal, and we'll be submitting on this.
626. Menino versus Waldorf Exteriors.
Mayor, appellant form 3, please.
Responding Waldorf 2.
I'm sorry, so you represent whom?
Appellant.
Waldorf, how much?
2.
I'm sorry, how much time are we requesting?
2 minutes.
Good afternoon. Respondent TDX, request 5.
6 and 2, 2 and 4. Leach versus GVC2 Inc.
Good afternoon, Your Honor. Plaintiff appellant respondent request submission.
Respond to GBC2 merit submission.
Matter submitted. Thank you all. McNaughton v. 5 West 14 owners.
Good afternoon, Your Honor. Appellant request 6 and 2. Is that correct? Is it pro se?
That was an excellent job. Now we'll wait for the respondent. You can remain standing. Okay, good. Now respondent, what would you like? 523. Now you can sit. Excellent. Baskerville versus New York State Office of Children. Hi, who are you?
Responding, Your Honor. 2 minutes, please.
There's no appellant. Do you still wish to argue against yourself?
Just, if the court will indulge me, just an opportunity to clarify.
Sure, 1 minute. Matter of, Susan. It's Susan Lederer versus Alexandra, excuse me. The matter is submitted. TCS Construction versus AmTrust North America. Who do you represent? And how much time are you requesting? 524. Echo Engineering versus Locust Solar.
Appellant 5-2.
Good afternoon, Your Honor. Respondent
525. People v. Niles. The matter is submitted. Certain underwriters. The matter is submitted. Wasani Asset Management versus Lou. Matter is submitted. First case for argument. People v. Michael Lard or Lady Yard. Yes, you may proceed.
Good afternoon, Your Honors. My name is Thomas Palumbo of the Legal Aid Society, and I'm here today on behalf of Mr. Michael Ledyard. We're here asking for a modest reduction in Mr. Ledyard's sentence. He was sentenced to 5 years probation. We are asking that that be modified to either a conditional discharge or the minimum term of 3 years probation. Mr. Ledyard is someone who has overcome numerous obstacles.
So the first question is the waiver.
Yes, Your
Why is the waiver insufficient?
Well,
Which
Your
would
Honor,
then
there's a
allow
couple
us-
of problems.
Sorry, go ahead.
Yes, with the waiver. First, Mr. Ledyard was told multiple times by the trial court, you're waiving your right to appeal. There's numerous case law, including Zono, Thomas, and Lopez, saying that suggesting that an appeal waiver is an absolute bar to an appeal means that it was not knowing, intelligent, and voluntary. And this problem was exacerbated by the fact
So
that
the court explained, you're waiving your right to appeal. However, now a defendant such as you ordinarily retains the right to appeal even after pleading guilty. Thus, a waiver of the right to appeal is separate and distinct from the waiver of a trial and other rights by plea of guilty. The court went on to talk about the differences between, the court went on to talk about what rights remained or survived the waiver of the right to appeal.
Yes, Your Honor.
Court said, by waiving your right to appeal, you do not give up the right to take an appeal by filing a notice of appeal with this court and a district attorney within 30 days of sentence.
Yes, Your Honor. However, the fact that Mr. Ledyard was told, and this is someone with very minimal experience, he has never seen an appeal waiver before.
So he was 51 years of age at the time of this incident and the
Yes,
time
Your
of the
Honor.
plea.
Yes.
He also was asked whether or not he had conferred with his counsel, whether he had any questions about the waiver. He stated no. He was asked whether he was whether waiving the right to appeal voluntarily and by his own free will and choice.
That's correct, Your Honor. But something that is important to note here is that Mr. Ledyard, who reviewed this, was given this written waiver of the right to appeal a day before the hearing. There was never any time where the court went over this waiver with him, talked about the written waiver at all, or had anything to say about that. Now,
Did
this
did
is,
his attorney go over the waiver with him, the written waiver?
yes, Your Honor.
He acknowledged that on the record, that he had gone over the written waiver with his client.
Yes, Your Honor. But in this case, there was still no opportunity presented by the trial court to talk about the written waiver. It was never addressed by the trial court. This was a situation where many...
So I'm sorry, so the judge asking the defendant whether or not he understood, whether or not he had gone over the waiver with his counsel, whether his counsel had explained it to him, and whether he had any questions, this was insufficient for a 51-year-old male.
Well, Your Honor, the judge didn't go through all of those things with the...
He did. The judge, I'm reading it. He specifically asked whether or not he had discussed these, whether he had discussed the waiver with his counsel. Defendant said yes. He asked whether or not defendant confirmed that he spoke to his counsel about the waiver and had no further questions.
Yes, Your
Confirmed
Honor.
that he read the waiver over as well.
Yes, Your Honor. But with the written waiver specifically having points that were not addressed by the court, then there was no opportunity to go over the written waiver specifically. And this creates...
What was contained in the written waiver? I'm sorry, I'm not understanding. You're stating that there's certain things in the written waiver that were not gone over by the court?
That's right.
Is there anything that says that the court has to outline or state everything that's listed in the written waiver?
There isn't, Your Honor, but there have...
Even have to be a written waiver.
The model colloquy says that that is the ideal and that is preferred.
That's
but-
because once upon a time, we only did oral waivers and we never had a written waiver. And we said, you know what? There should be a written waiver so that a defendant sees exactly and can read for him or herself exactly the rights that he or she is waiving. You have time on rebuttal. Thank you.
Good afternoon, and may it please the court, Paul Anderson for the people. I just want to put this in context that this was a very heavily negotiated plea in which Mr. Ledyard,
So he pled guilty to the attempted criminal possession of a weapon in the second degree.
yes, to see violent.
The indictment charged him, I'm assuming, with the attempted criminal possession of a weapon in the second degree?
It charged a completed criminal possession in the second degree.
This is a plea in which, in order to get to this sentence, the court had to find mitigation because the minimum time on this wasn't probation, but 2 years.
Yes, Your Honor.
So he had to plead down, right?
We had to plead down, and also we had to put forth a 65
Even on the pled down
application.
charge, the minimum charge without mitigation was 2 years incarceration.
2 years incarceration and 2 years post-release supervision. And so here, this was negotiated. We factored all this in, and part of that, who the defendant was out at the time, was you were waiving your right to appeal the excessiveness of the sentence. And as Your Honor's pointed out, this tracks the model colloquy nearly word for word. And him and Mr. Ledyard complaining that he had the appeal waiver the day before, in which he could talk to his attorney, then goes to court the next day.
Defendants get the appeal waiver the day of, right?
Yes, but here there was actually appearance before, and he was actually given that waiver, but he
Right, so the
wanted his own
point
counsel,
is,
yes.
for this individual, he had even more time to review it, to discuss it with his attorney than many defendants have.
Yes, Your Honor, and of course, the court did its duty in double checking. Yes, did you talk to it? Do you have any questions? And no questions.
And, excuse me. Let me turn my mic on. Now it's on. And counsel talked about mitigating factors, but here we have a minimal criminal history, obviously some health challenges, and a family support. But didn't the court take that all into consideration when sentencing?
And yes, and put the people to their burden to say why these meet the factors of institutional confinement would not be necessary here, why he would get the benefit of the probationary services, and why the interest of justice favored the probationary sentence. And we went through all that. All that was considered. And even after that, the pre-sentence report or statements to probation, I think, depending on the prosecutor that day, could have undermined that whole agreement, in that it seems he added all these extra embellishments that weren't before the court before. I was getting this gun for months
He did have
prior.
a prior conviction, did he not?
Yes, at
Long
2000.
ago, but in 2005, he had pled guilty to a drug felony, right?
Yes, Your Honor. And that was also factored in here. So the appeal waiver is valid here. And in any event, this probationary sentence is appropriate for this defendant.
Because
Sorry.
that's okay. Because in fact, after the court asked the defendant if he spoke to counsel, and the defendant said yes, the court said, "Do you have any more questions about that?" And the defendant answered no, right?
Correct, Your Honor. So ample opportunity, more so than I think many of the cases that come before this court. And in any event, this sentence, I think, is more than fair and cannot be described as unduly harsh.
Even if we were to find that the appeal waiver was invalid, he still got a sentence a lot lower than what he would have gotten.
He received the benefit of this sentence
Without
that was,
this
again,
offer.
heavily negotiated and really factored in all these mitigations and to try to make him avoid having another lapse of judgment, as he described it himself. And so if Your Honors have no further questions, I ask that you affirm.
Thank you.
Thank you.
Your Honors, I'll just say briefly that this court and the Court of Appeals have found that discrepancies between an oral colloquy and a written waiver have been enough to make it unclear and to make it not knowing, intelligent, and voluntary. And that is the situation that we have here. And I would just
Where's
like
the inconsistency?
the fact that there was no point where the trial court went through what rights remained and what rights Mr. Ledyard would have on appeal, and telling him multiple times that he was waiving his right to appeal as a whole rather than having those remaining rights. And
How is this sentence excessive? Even if, let's say that we find the waiver is not valid, how is this sentence, this specific sentence, excessive?
yes, Your Honor. So in this case, Mr. Ledyard is someone with a very minimal criminal history who immediately accepted responsibility, telling officers on scene, "I made a mistake, I own this." During the pre-sentence interview that counsel referred to,
But what was he doing with this gun in the car? He said he was bringing it to his girlfriend's house, but he lived with his girlfriend. So how does that match up with the fact that he wasn't bringing?
well, Your Honor, he was on his way to his girlfriend's house. What he told police was that
He lived with his girlfriend, so why did he, if the gun was being left where he lives, that was in his girlfriend's house, so why was he with the gun in the car at that time?
And not only that, he stated that a friend of his or someone had given him the gun a while ago. So why did he select this particular day to take a cab to his girlfriend's house, where to leave it at his girlfriend's house, where he, as my colleague stated, he lived with his girlfriend and his mother and others?
Yes, Your Honor, it is beyond the record why that specific day was why he had the gun, but what he told police immediately after he was caught was that he accepted his mistake. He said
Right,
that-
he accepted his mistake in being in possession of a loaded firearm. It had 3 live rounds. Thank you.
Yes, Your Honor, but I'd like to just highlight in the brief time I have left that this is someone with multiple health injuries, and as has been noted by people including Bronx District Attorney Darcel Clark, probationary terms after the first 18 months.
So his probation would terminate in September 2026. So we're talking about a little bit over 1 year. Is that correct?
Yes, a little under 2 years, Your Honor, and he's been serving this term for over 3 years now.
Thank you. Thank you both.
Thank you.
Konstantinovic versus Finch. Yes, you may proceed.
Good afternoon, Your Honors. May it please the Court, Matthew Corcoran for the defendant appellant, Appellate Incorporated. Your Honor, this lawsuit was commenced by plaintiff alleging that he was injured while working on the boiler in the building where he is employed as a superintendent. Now, the summons and complaint and the workers' compensation form that he signed and filed indicate that the accident occurred when he fell from a ladder. My client is a boiler repair company who has no ownership responsibility for this property.
You worked in the boiler room before the occurrence, hadn't you?
They had, Your Honor, yes.
So the accident occurred on March 21. Your company apparently worked in the boiler room on 3/15, March 13th, I think, and March 15th, right?
Well, Your Honor, let me clarify one thing there. The accident was March 20th, 2021. My client first comes to actually work on the boiler March 21st, 2019. So accident March 20th, my work March 21st.
Hadn't they been in those premises working in that boiler room before that date?
They had, Your Honor, yes. But here's the issue. So as I said, the complaint in the workers' comp form lists this as a workplace accident because of a fall from a ladder. And my client's been to the property to work on the boiler, but they don't have an ownership responsibility, no contractual or statutory responsibility to the property, to the plaintiff to provide a safe environment, and they weren't present on the date of his actual accident.
But the day after, there was a contract, right, or an invoice between your client and
The building owner,
the
correct.
building owner, right?
Yes, Your Honor.
And again, you had done work there prior to the date of the accident.
Prior to, yes, those 2 dates
Did you
that you...
submit anything stating, any invoices or anything other stating that you did no work the day of the accident?
Well, that's admitted, actually. That's admitted by the plaintiff. It's admitted also by the co-defendant, former co-defendant, Finch Apartments, that they didn't retain us to do the work until the day
Why
after
isn't
the
there a
accident.
question whether the work you did in the boiler room before the day of the accident may create liability? And you have the burden, and you didn't present any evidence on that subject.
Well, Your Honor, I'd argue that we did, because again, at the time we filed our motion based on the documents, the complaint, the workers' comp form, this was a ladder accident. We're not responsible to provide plaintiff with a ladder.
Well, no, he was on the ladder because he had to fix the boiler.
Correct, Your Honor, and I think that's an
Right.
important note, actually. He has to fix this boiler, which the building owner knew had a leak. Now, we were at the property doing work sometime before this. The dates that Your Honor was referring to, the 13th and the 15th, was us going to the site to prepare the proposal. Now, at the time we are called out to do the proposal, the boiler's already leaking. That's the reason my client is called out there to address the boiler. So whatever we did during the proposal didn't contribute to the issue that already existed. But my point is, again, in opposition to our motion, the plaintiff filed only an attorney affirmation, and that is where, for the first time, the allegation is contained that there was a leak that contributed to the accident. The complaint says defective ladder, fall from a ladder. The workers' comp form says fell off a ladder. And I would argue that...
Does it matter that this is a motion pre-discovery? You're moving for summary judgment pre-discovery?
No, I would argue, Your Honor, it doesn't, because based on what we had when we made our motion, we made our prima facie case showing entitlement to summary judgment, that our client has no responsibility to the property as a boiler contractor. And I would argue in opposition to a prima facie case, they need to submit factual information to create a question of fact, and that fact can't come from an attorney alone.
Well, what about the emails, though? So we're back to the emails, because I thought I didn't see anything in the emails that suggested that it was just there for some type of estimate. I thought that the email suggested that there was actually work done by your company in the boiler room.
No, Your Honor, and in fact, the lower court's decision actually references that we didn't do the work. They just referenced that we came there to prepare the proposals prior to plaintiff's accident.
Well, the email, I'm going back, March 15th, there's a request to pay for all of the invoices, but there was no indication regarding what that work was.
Right, but well, I'm referring to the dates that the proposals were prepared. There's prior work done some time ago.
And that's what we're talking about.
What type of work was done
We
some
don't
time
know.
ago?
Yeah, it just says requested payments for old and overdue invoices.
Well, Your Honor, let me put this to you. So there's a leak in the boiler before my client is there. Now, plaintiff's argument is that our motion was premature and that my client is in possession
But
of the
what caused the
information.
leak?
Well, but this is what I'm getting at, Your Honor. If there was a leak after my client did some prior work, my client isn't on site. They don't have that information. So it doesn't make sense for plaintiff to argue my motion is
We also
premature.
don't know if that leak was caused by your client's work.
Right, that's the point.
Right, but my point is, if there was a leak continuing after my client did work, my client's not on site. My client's not in exclusive possession of that information. That's the point I'm making on prematurity. Plaintiff is the superintendent of the building. If there is a leak that continued after my client did their work and left the site, my client's the only one out of all the parties in this case who's not going to have that information. And that's why I argue the premature argument requires exclusivity.
Your
that my
client would not have information as to whether you were on site or not, or when you were on site?
Not whether they would be on site, because, Your Honor, the mere fact that my client may have worked on the boiler doesn't allow the inference of negligence. The fact would have to be that my client did the work negligently, and my client's not going to know if there's a continuing problem with the boiler after they leave the site. That's my point, Your Honors.
Okay, you have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Victor Bodo, Stockholm Filas for the plaintiff respondent. The first issue here is whether the appellant met its prima facie burden. It did not. The Supreme Court found that it did not meet its prima facie burden of establishing there are no questions of fact here. In fact, excuse the choice of language, but
They say we worked after this happened, so what do you want from us? How can we be responsible for it? So why does that not establish a prima facie case?
because the evidence they chose to submit, which we do not have access to, show that they had outstanding invoices for some type of work in the boiler room. That's in our summons and complaint. We said that they negligently installed, maintained, repaired.
Wouldn't your client know what kind of work they did on their boiler?
He's the superintendent. So
No, well, okay.
he's a superintendent. So that's outside of the record, and because it's a pre-answer motion, we don't have the
If he's superintendent, wouldn't he know what's going on in the boiler room?
One would hope, but we don't know. We don't know for a fact whether he does because we haven't had the opportunity to exchange discovery. We haven't had the opportunity to particularize our allegations through a bill of particulars. So maybe.
But Finch Apartment Corporation is what hired, is the entity that hired Abilene. Is that correct?
That is accurate.
So you saying he's the superintendent, but your client is the corporation, is the building. So would the building not have those records?
The building would have those records, but the building got out on summary judgment, and we haven't been able to get discovery from them. So the building, the building Finch would have that information. Abilene itself would have that information. So most likely, Abilene would have even more information because they would know when they were on site. They would know exactly what type of work they did. Finch might just have the contracts. They wouldn't actually have they wouldn't know exactly what they did on site. So Abilene admits it was on-call maintenance company. The emails they submitted, rather than extinguish questions of fact, they raised questions of fact about exactly what they did on site. And that is exclusively in the control of Abilene. And more importantly, there's this red herring about whether they were on site on the accident date. Now, whether they were on site on the accident date or the day after really doesn't...
What did you do to get the records from Finch?
We haven't been able to because this is a pre-answer motion to dismiss. We have not been able to request those records.
So Finch also got out on summary judgment pre-answer?
Yes. They both made the same motion and the same decision. They got out on the workers' comp exclusivity provision. So Finch is out. We haven't been able to get that discovery. And there's no requirement in the law that Abilene has to be on the premises on the date of the accident. We know they were on the premises.
You say this is a pre-answer motion for summary judgment. Didn't Abilene answer on June 1st, 2022?
I misstated that. I'm sorry.
And it's on January 2023 that Abilene first moves.
I misstated that. It was a pre-discovery motion for summary judgment. And because it was made at that point in time, because there was no discovery exchange, because there was no preliminary conference, we were unable to get that type of discovery. And the motion was premature because the invoices, the contracts, the repair tickets that they had exchanged with Finch would be in the exclusive possession of Abilene. And third, there's an allegation that we brought a new theory of liability.
Well, what discovery did you seek from Finch which you didn't receive?
There were no demands made at that point in time because there was no preliminary conference held. So that was not made. That was not done. Because at the time
You need to have a preliminary conference before you can seek discovery?
that wasn't required, and that's what the lower court, that's what the Supreme Court also found in its decision, that because it was done so early, that there was no opportunity to do that.
Thank you.
Real briefly, Your Honor, I just want to discuss something Your Honor alluded to about who this plaintiff is. We're not dealing with a tenant of the building or a guest or a delivery person. This is the superintendent of the building. So the fact that he is claiming that he doesn't have knowledge and information sufficient to oppose our motion is ridiculous, especially when you consider the specific task his employer, the building owner, asked him to do at the time the accident was occurring.
He wouldn't have the actual records. That's what he would. I mean, he may have a general recollection as to when Abilene came in to fix something, or whether they came in to fix something, et cetera, but he doesn't have actual records of the same.
Your Honor, just because my client might have information he doesn't have doesn't mean that he needs that information to oppose my summary judgment motion. Again, the allegation of a leak was only in an attorney affirmation. The plaintiff was well within his ability to submit an affidavit detailing the exact way the accident occurred, detailing the work his employer asked him to do.
Did the plaintiff do anything to obtain this information?
I'm sorry, Your Honor?
Did the plaintiff do anything to obtain this information?
No, we never got any discovery demands from plaintiff either for us or that we saw from Finch either. So that and
you
that's
would have been served with a discovery demand which was made on Finch. You would have been served with that too, right?
I presume I would. Yes.
So at what point did you move for summary judgment?
We moved for summary judgment after our answer, Your Honor. There was no discovery exchange at the time that we moved. But again, Your Honor, I just want to point out at the time that we moved.
Didn't you answer in June 2022 and you moved in January 2023?
Yes, Your Honor. We moved concurrently when the building moved because our papers kind of supported each other. They supported the notion that we hadn't done any actual work at the site respective to that particular leak by the time the plaintiff's accident happened, and the papers were kind of...
We don't know that, because the thing is, in the supporting affidavit, it's obvious that Abilene reports there on an on call, but the affidavit doesn't talk about what type of work you did when you were on the premises before. It's obvious that you were there previously, based upon the email, but you don't even say what you did before.
I understand that we don't say what we did before, Your Honor, but again, I want to just real quickly, our motion was based on the latter allegation. In opposition, they submitted an attorney affirmation that talked about a leak for the first time. I would put to the court, we made our prima facie burden, and if they're going to change the theory of liability to a leak, it needed to be done by an affidavit from the super who was tasked by his employer to work on the boiler specifically to repair this leak at the time he alleges his accident happened. That affidavit is information within the plaintiff's possession, and he could have used that to oppose our summary judgment motion, but they still provided nothing. Thank you, Your Honors.
Sola versus Harlem Urban Development.
Good afternoon, Your Honors. Matthew Lavoie of Woodsmith, Henning Berman for the defendants appellants. With respect to Labor Law 240, there were material issues of fact as to whether plaintiff was the sole proximate cause, as to whether the ladder was a proper safety device, and as to whether the ladder was wet. First, as to sole proximate cause, I really want to highlight three cases cited in our briefs. That's DiSembrino, Antonucci, and Bonskar because of the similarities here. In this matter, plaintiff claimed that he fell because he slipped on a liquid concrete substance on a rung of the ladder. However, this conflicts with the testimony of plaintiff's coworker, Luis Fernando Loja, who witnessed the fall and testified that plaintiff fell because he stepped wrong. And
Did he also say that the ladder was full of cement and wet, and it was so dangerous that they had to put sawdust before they came down to assist the plaintiff?
There was some testimony, which the lower court cites, I believe, in the order, that he said that the ladder was wet. However, later on, he corrects that prior testimony, saying that the floor was wet because of the concrete pouring. He said not the ladder, it was the floor that was wet.
How does Lugo's testimony get you out of liability? Because this ladder wasn't a safety ladder. So there's no device protecting the plaintiff against falling off of this ladder. He could have been attached to a tie-up to prevent just what happened here.
So, Your Honor, the ladder, these were ladders that were job built by plaintiff's employer, by Sky Materials. They were equipped with handlebars for workers to hold on to. They were affixed to the
The
floor.
handlebar is not going to protect you from falling, just as happened here. I mean, even assuming that he missed a step, that doesn't mean he has to be falling. If he had had a safety device which would have tied him up to a tie-up point, he wouldn't have fallen.
Well, Your Honor, Sky Materials did not require any harnesses or any tie-off points for these ladders. I think Antonucci and DiSembrino supports the facts here that it was a ladder. There's conflicting opinions about what happened, about whether plaintiff missed a step or not. And just because of those two conflicting accounts, that's enough to find an issue of fact. Certainly, it's not enough to establish sole proximate cause, but it's an issue of fact. And that's what this court found in both of those cases. I might add, both of Your Honors were on the panels for those cases. So I would suggest that those are extremely important to this fact pattern, just because of the conflicting testimony on what caused the fall. He missed a step. That conflicts with plaintiff's testimony. Another important case is Bonsar. And in that case, the defendants asserted that plaintiff's failure to maintain 3 points of contact on the ladder attributed to plaintiff being the sole proximate cause.
I have pictures of the ladder. It's crazy. I mean, the handrails are not going to assist anyone in terms of descending the ladder. I mean, it's like a straight down. It doesn't appear to slant in any way. And I do not understand how there could not be a tie-off. And I don't understand how you could claim that it was a sole proximate cause. How is he to hold on to this sole handrail and carry the bucket down the ladder?
Your Honor, he could have done something aside from holding it in his hand.
Aside from holding his hand?
Yes, he testified that he was holding a water thermos in his hand.
Right.
Obviously, if you're descending a ladder with that in your hand, you're not going to have 3 points of contact, even though he was instructed to maintain 3 points of contact with the ladder. And that's why Bonsar is applicable here, because it's the same issue. Both plaintiffs were instructed to maintain 3 points of contact at all time, and they didn't do it. He had something in his hand. He testified. Because of it, he wasn't really sure if he was able to hold on to the ladder with both of his hands. And specifically, the fall happened when 1 foot was about to touch a rung. So at most, he had 2 points of contact. Therefore, he was misusing the ladder, which caused the fall.
He was misusing the ladder?
He was instructed to maintain 3 points of contact, and he failed to do so.
I just want to go back to the supposed issue of fact about the ladder being wet. So we have the plaintiff testifying that the top of the ladder was wet. You agree with that?
Yes.
Okay. And then Donahue, he was shown a photo, and he indicated that he saw that the ladder was wet. Yes?
No, Your Honor.
No?
Donahue testified that there was, I think he said definitely concrete, which I think is something that the lower court and respondent latches onto.
All right.
He was referring
Okay, well, let's move on, all right? Because
Your Honor,
no. I want to move on. And so then we have the coworker. And so whether it was the whole ladder or portion of the ladder, regardless, he indicated that he saw concrete, it was wet. You agree with that?
he said there was concrete on the floor, not on the ladder. There was no testimony other than plaintiff that the ladder was wet. In fact, Mr. O'Donohue, Mr. Loa dispute that fact.
Well, I guess counsel will address this because I don't see it, but he'll address it.
Any significance to the fact that he was told not to use any fall gear?
I'm sorry, Your Honor?
Any significance to the fact that he was told not to use any fall gear?
He was told not to use new. I'm sorry, I don't remember that piece from the record. Who did? I'm not sure who told him that.
That he was not told to use any fall gear.
Well, I'm sorry, Your Honor. I'm not sure what you're referring
Was there
to.
any direction to use any fall gear?
Not that I know of. No.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Brian Isaac, I represent the plaintiff respondent. Your Honors, let me just say something because I think it's important. There is no contrary testimony. I'm sorry. There just isn't any contrary testimony that there was concrete all over this and that it was wet. It's not there. My adversary cites to 1120, starting on line 16 to 1121, going to line 8. He's talking about a photograph. Loha's testimony didn't repudiate where he said that it was wet and there was concrete all over the place.
So how do you do with Loha's testimony that he missed a step?
It's just a characterization of a fall. And in fact, in the O'Shea case, which we cited, that's not even inconsistent because you do miss a step when you slip. That's not an inconsistent statement. And that goes back actually to a case called Rahm against Eurostruct or Hill against City of New York, which says that's not inconsistent. If I can also, if you look at 1138, which is the other section that he cited, 1138, starting on line 2, all the way to line 8, they're again talking about a photograph. They're not talking about what happened in the accident. So there is absolutely no inconsistency whatsoever in the testimony. It's predicated upon a misapplication of that testimony. And all I ask you to do is read it. With respect to the issue of fall protection, there was none. The
No, there
plaintiffs.
was no fall protection, but your friend stated that they were told that there should always be 3 points of contact or whatever when descending the ladder.
I can handle that in 3 seconds. Look at Gordon, look at Higgins, look at Stolt, okay? And in general instruction not to engage in unsafe work practice is not, has never been, and will never be a defense to a Labor Law 240 sub 1 case, period. Bonskars was not a 3-point contact case. The issue in Bonskars was the fact that plaintiff was the one setting up the ladder and not checking. That's what the lower court said. I would also point out to the court that Mr. O'Donoghue, their star witness, said you don't have to use fall protection when you're descending the ladder. So that's not my client's fault. As far as I remember, 240 of the labor law requires owners, general contractors, and
Is this
agents.
a case that the ladder that we're talking about, you needed to have a harness if you wanted to avoid 241 liability?
You can just look at the photos, as Judge Weber said, 100%. There's no fall protection here at all, and the ladder's defective. It's
Well,
wet.
that was the other thing. It does seem as if the ladders are defective because even with the railing or what is called a railing, I don't see how you're able to descend that ladder.
You can, and look, I don't know what
It goes straight down. It just
Straight down.
Straight down.
I don't know what a piola is. I know that they use the term,
Yeah.
okay? But I think if you
I
look,
Googled it.
you do, okay, you're better than I am. But I counted. There are 5 references to the fact that when the plaintiff was descending, 5, he had both hands on the railings, and that the piola was either on his wrist or on his elbow.
Right. So the railings also seem to start as, towards the middle and not the beginning.
Yes.
It's
That's true.
Almost to the end.
That's
To
100%.
it's almost to the last step down.
Right, so my point would be on that is that not only is it defective going down, but when you have wetness, undisputed wetness, and witnesses saying there's concrete, and as one of the panel members mentioned, this was so bad that after the accident, they put sawdust down, and according to Loha, they had a meeting the next day because the concrete pour would cause wetness and concrete to go onto the ladder, that they said, make sure you go down carefully.
Any consequence, or what do you, how do you respond to Mr. Is it Shawalski? Jeff, the expert, the defendant's expert?
Simple.
His affidavit?
Simple. Experts can say things. Sometimes they constitute evidence. Sometimes they don't constitute evidence. His affidavit is wholly conclusory. There are tons of cases. Rincon is one of them, which is mine, which says that you cannot defeat summary judgment where an expert says that a pure labor law violation isn't a labor law violation, and his argument makes no sense. What he says is the ladder was appropriate, but he doesn't deal with the fact that there was no fall protection, and he doesn't deal with the fact that the ladder was wet and had concrete on it. So the ladder can be perfectly stable, but if it's defective for other reasons, you have to deal with that, and he absolutely didn't. It's
Well, he states that the ladder was appropriate, that the plaintiff had used the ladder several times on the same day of the accident, and that his accident was not the result of the lack of any appropriate safety devices.
Of course, conclusions unsupported by any facts. And Judge Weber, I would point out to you that the plaintiff testified that the ladder was wet even before he used it, but he was able to avoid a fall. So again, I don't see anything wrong with the trial court's decision here, and I would ask that it be affirmed. Thanks for listening to me.
Thank you.
Your Honors, despite respondent's argument, there is a dispute, a clear dispute as to whether the ladder was wet on record page 1121. This is Loja's testimony. Question: is it your testimony that the ladder isn't actually wet, but the top part where the concrete is poured, isn't that the part that's wet? His response is yes. So he clarifies.
But again, we're looking, as was stated, he's looking at photographs, right? Is this not in reference to the photographs, or in reference to his observations after the incident?
Your Honor, I'm not sure if it was for the photograph or his memory specifically.
It seems to me that they were directing his attention to the photographs. Back to your expert's affidavit, how, as an engineer, can he state with any degree of certainty that there was no violation? Because he states that it was the plaintiff's own fault in not using. He states that his accident was not the result of any lack of appropriate safety devices, but rather defendant's own conduct.
What's the basis of that opinion?
Yes.
I mean, he reviewed all the pleadings, all the testimony, his experience in the field.
But even granting you if the ladder wasn't wet, isn't this a ladder? The nature of this ladder called for having a harness if you're going to avoid Section 241 liability.
Your Honor, plaintiff's employer specifically did not require harnesses to use this ladder. It was the course of business to not.
Well, whether plaintiff's employer required it or not, I mean, this was a dangerous ladder to be using. And if you're putting an employee on that type of a ladder and you want to escape being liable under 241, you had better give that employee a harness and a tie-off point.
Your Honor, this is a ladder that was constructed by Sky Materials. As far as fall protection, they did provide fall protection. There was
I'm not saying they didn't manufacture the ladder correctly, but that doesn't deal with what safety device you might need to use when you're using this ladder.
Your Honor, it's our position.
It's an A-frame ladder.
Correct. It's a job-built ladder. There was fall protection. The record states that there was orange netting installed near the ladders, which served as fall protection. There were no broken or missing rungs. Plaintiff had no recollection of the ladder shaking or moving. Plaintiff used the ladder 4 to 5 times a day without any issue. His coworker went down the ladder directly after the accident with no problem because he, quote, was careful.
Thank you. Thank you both.
Thank you.
Fresco v. 1BK Street Corporation.
Good afternoon, Your Honor. Adina Levine for Appellant's Cross Appeal Respondents. There are 2 areas that the court below erred. The first is that it failed to enforce the terms of the good guy guarantee, which provides that where a guarantor, like my client who is in the room here today, basically prepays 6 months worth of rent, he is then able to be absolved from liability going forward. And he complied with the terms of the good guy guarantee. The court below
Was that
erred.
the only term of the good guy guarantee? Were there not other terms that had to be fulfilled as well?
Correct, and he did comply with those
Fulfilled
as
all
well.
of the terms of the.
So the court below made a mistake in when it said that he should have waited an additional 3 days before vacating, when really, if you looked at the undisputed facts here, he had actually, the court said that he should have waited until November 5th, but whether it was November 2nd, or November 5th, he had actually prepaid through November 9th, and that's from landlord's own records.
The notice that he gave was that he was going to vacate on November 2nd.
Well, so that the real thing is that a little bit this is all a straw man, because he never, and this is my second point on where the court erred, he never actually even moved into the premise. So the idea of when he vacated is really ridiculous, because he had never even actually moved in. So the issue is really not when he actually left the premises, it's how much he had paid for. And he had paid for through November 9th. The terms of the guarantee specifically say that he could vacate at any point up until the date, and that, the date of the 3 months or the 6 months, and he had vacated actually even earlier. The point that he had never even, this is my second point, he had never even moved in is because the rent commencement date under the terms of the lease was November 19th, 2018. Between the time that the lease was signed and November 19th, 2018 was when Con Edison discovered a leaking gas pipe that it needed to shut off. And so that's why under the section 3.2 of the lease and 4.2J, the rent commencement date doesn't start until landlord fixes that pre-existing condition, and he never did that. So the rent commencement date never actually started, and that's the area where the court below erred, because it didn't look at that provision and realize that that means that they shouldn't have dismissed his first cause of action for, among other things, frustration of purpose. They shouldn't have dismissed the cause of action for rescission of the lease. They shouldn't have dismissed the cause of action for breach of contract in part. So basically, those are the two areas that I wanted to focus the court on, is the guarantee, focus on the vacation, what time that he vacated was a bit of straw man, because he had never been in the place, and even landlord himself admitted that in his
But yet you do
papers at page 5.
recognize that you had to give notice under the good guy guarantee, because you do give notice.
Correct.
So you didn't take that position as you were dealing with the landlord. You took the position that we have to notify you. How
Well,
does that
he
square
paid
with what you're
rent
telling us
all
today?
along, meaning in terms of taking that position, he paid rent all along because my client was trying to avoid the exact reason we're here today. He's trying to get it to work.
How are you excused from the notice requirement? And then we have the next question, did you comply with the notice requirement? But you obviously didn't take the position, I don't have to do anything because we never moved in. You did give notice.
No, my client was dotting his I's.
So Supreme Court said your notice wasn't good. In what way?
So they said that it had been delivered by email and regular mail
It wasn't
instead of
actually
in person.
received until August 5th is the date?
So that's the idea. Now, I just want to
And
say.
you moved out on November 2nd?
Correct.
So you needed to move out on November 5th in order to comply with the 3-month?
That's what the Supreme Court said, but I do want to just say, as a preliminary matter, this court has held repeatedly that strict compliance with notice provisions is error when the defendant has actual notice and has not been prejudiced. So the 3 days as a preliminary matter.
Guarantees?
Yes, that's Suarez
And
versus
just, and
Engel.
just to correct something, it's not that your client had to move out on the 5th. It was that your client noticed that it was moving out by the 2nd.
Correct, but my client, I just want to be clear, and I think you guys get this, the client had never, ever moved in. So it's really a question of when he gives back the keys. The landlord himself said, give back the keys, and he accepted the keys. He accepted the prepayment of the rent. And even the landlord's own documents, the general ledger, which is at R 604, 605, and the client's landlord's own testimony said that he thought that our guarantor was free and clear, that he owed no more rent as of March 2020, and that's at R 7.
If I understand you correctly, then and you tell me if I'm wrong, I take it that your position is we may not have met the strict letter of the agreement with regards to the notice, but who cares? Because we were never in there, there's no harm, and they were on notice.
Okay, so thank you for asking. That's not my position, because I do want to say that the first idea is that we were never in there. But if you look under the terms of the guarantee, it says that you can move out anytime before that date in the notice. That is
How
R
do you comply with
578.
how do you comply with the 3-month notice?
Because he gave the notice on August 2nd. The landlord received actual notice, and he had paid through the 9th, not the 5th, not the 2nd, through the 9th.
You're conflating two things. You're conflating the payment with the notice.
Correct, but because he had never moved in, the notice is about the payment.
So if you gave notice on August 5th, How did you comply with the notice requirement?
So that's exactly what he was asking, is that he had paid through the 9th. So whether it was the 5th, the 2nd, or the 9th, he had paid through the 9th. He didn't ever move out because he had never moved in. He handed back the keys early, but that's not the same thing as not having given the notice. He gave the notice, the landlord had the notice through the 3 months and then through the 6 months.
Thank you.
Good afternoon, Your Honor. It's Jack Malley for
If we're
respondent.
understanding counsel's argument correctly, why doesn't she have a point? The notice is dated August 2nd. We're going to assume that it's, as Supreme Court apparently found, that the notice was really given August 5th. Tenant moves out November 2nd, 3 days early on the 3 months, but you've paid up until you're paid rent until the 9th. You're given the keys on November 2nd, so who cares? You moved out early, but so we'll deem the return of the keys effective November 5th. If they got out after November 5th, I understand you have an argument to say we've got a problem, you didn't comply with the requirements, but you have up to the 3 months to get out. Why doesn't that satisfy the requirements of that provision in the lease that you're out of the good guy guarantee?
Well, thank you, Your Honor. This is a lease that was entered into by sophisticated parties with sophisticated lawyers representing them. There is a condition that needs to be strictly construed with that sophistication. The notice provision says that notice has to be given 3 months prior to the date noticed of vacation. And it also says if it's mailed, the service date, 3 days is added.
That gets you to the August 5th.
That gets to the August 5th.
And when did they get out?
Well, it's notice of the date of vacation, and the date to vacate was November 2nd. It's notice of that date.
When did they get out? Didn't they get out November 2nd? Didn't they leave November 2nd?
They got out at or around that date, but the point is the notice didn't meet the notice requirement in the lease. It had to be given.
This is just a hyper-technical reading of the, it required 90 days. They mailed it out on, they sent it out on August 2nd. It's deemed received August 5th, so they're out of it because in their notice, they said they're going to be out November 2nd, and they should have said November 5th.
Yes, it is technical, but
how do you deal with that? How do you deal with that in light of the fact that they never moved in?
Actually, that's not true. They did have an event in the premises. Prior, they had trouble getting the gas, and I'd like to talk about my arguments.
Not trouble, but Con Ed said that they gave him there was a red tag, which was, we don't know whether it's a warning or a violation concerning the gas situation.
Well, this is in the affidavit of the principal. They had an event with no cooking early on in the lease term, so they did take possession.
I thought this was a restaurant.
Yes, it is a restaurant. So they had an event at the restaurant prior to the gas being connected. It never got connected. So they did move in at a point. But yes, it's a notice question. It's a strict construction.
Is what you're asking us to adopt a commercially reasonable outlook on things? The notice is dated August 2nd.
Right.
So because it's by mail, we're going to deem it August 5th.
Right.
But the August 2nd notice says we're getting out November 2nd. And in fact, they get out on November 2nd. But since there's this provision which says let's deem the 2nd the 5th, when you get out on the 2nd, that's no good because you needed to get out on the 5th.
It's a question of notice, and the 3 months notice
I don't
was
understand.
not
You
given.
keep saying it's a question of notice.
Yes.
They notified you that it would be the 5th, but in actuality, they left on the 2nd. So I'm not really, is that not correct?
I mean, if they had left on the 6th, I'd understand you're standing here with this complaint.
Right. What I just said, that's correct, right? They notified you it was going to be the 5th, but in actuality, they left on the 2nd. Is that correct?
No, they didn't notice that it would be the 5th. What the situation is, the notice provision says
When did they notice they were going to get out?
the date of the letter was August 2nd, but under the guarantee, if you mail it, 3 days are added for the service date. So the service date was technically August 5th. If you add 90 days to that, that wasn't sufficient notice of the November 2nd.
What did the letter say? What date did they give in that letter that they were going to get out?
On November 2nd.
November 2nd.
But if you add the 3 days of service.
But we're
it's
back to the
August 5th.
same thing. They were supposed to be November 5th, and they get out November 2nd, right?
Also, but they had paid rent.
And they paid rent through the 9th, which I'm not understanding. How were you harmed by all of this?
It's a matter of strict construction of what it says in the
And that's it.
guarantee.
And that's it. It's just
It is strict construction.
It's
yeah.
strict construction.
It's strict
So because it's strict construction, although there's notice, they vacated, they paid the rent, it's strict construction, and therefore you you should be somehow compensated for this, right?
Compensated.
Something for which you, in actuality, you got a benefit because they got out earlier.
Exactly. They got out 3 days early.
And they paid you for the period.
They got out 3 days early, and they got out on the 2nd, but you got 7 days additional rent.
They did pay it. That was part, if they surrendered, they had to pay that. So they did pay that. I think, as Your Honor said, conflating issues here, notice versus payment.
I'm still trying to figure out how you're harmed, how you have been harmed.
It's a breach of the notice provision of the guarantee.
And in addition, they paid you the other 3 months' rent, which they were required to do under the good guy guarantee. So they completely paid up what they were supposed to pay in order to get out under the good guy guarantee.
The other conditions they met, but they did not meet the notice condition.
So had there not been this thing that says that adds 3 days for mailing,
Yeah.
they'll be in full compliance.
It seems like that's the case, but that's the way it was written among sophisticated parties with sophisticated lawyers.
Thank you.
Would I have a chance to argue some of my points?
Oh, you're out of time, but thank you so much. We have the briefs.
Okay.
Thank you, Your Honor. Just, I want to hit on one point that you were making. As you heard from my friend here, he's basically asking you to strictly construe the guarantee, and he keeps saying it was negotiating between
Isn't that
sophisticated
what's always
parties.
done when it comes to guarantees, to release the guarantor from its obligations? It's the guarantee strictly.
Well, I just want to correct one thing. This lease was drafted by the landlord. There is no provision in here that said it should not be constructed against the drafter, and the law is actually the opposite of what my friend here is asking, that you should not strictly construe notice provisions where the landlord or where the defendant has notice and has not been prejudiced. And here he is actually seeking to sue my client for 15 years worth of rent over this difference of 3 days, where he acknowledged he actually had receipt. He emailed us back, that's at R708, that says, I got your letter. So it's not that he didn't have notice. He moved out early. So at best, they moved out
There's
early.
definitely an
and he
intention
prepaid.
here to free you of this 15-year rent obligation if you complied with paying the 6 months' rent and you gave the
That's
three
exactly the
three
point.
months' notice.
That's exactly the point of the good guy guarantee, and there's New York courts enforce the good guy guarantees. It's a matter of public policy, both to protect guarantors and to protect property owners, so this way they have that prepayment of the 6 months rent, and to encourage people to enter into guarantees. And then the last other point I wanted to mention is you kept asking him, what date did they get out? What date did they get out? And you saw him in awe because they never got in. Under section 3.2 and 4.2J of the lease, the rent
Well, he said
commencement
that you
date
had
did not.
some type of event or something where there was.
I honestly
cooking.
don't know. That was not in his papers, and I don't know what he's referring to.
The other side, of course, I mean, we've been over it, is as to the good guy guarantee, you obviously dealt with this as if you did need to give notice and gave notice. So.
Correct. Thank you, Your Honor.
Thank you. You have 2 minutes in rebuttal, counsel.
A few things I'd like to say. This lease had so many provisions that required the tenant to take care of all. This whole case is about whether
You were
or not.
supposed to take care of the Environmental Control Board violation, which you didn't immediately. There was a leak of a feeder pipe, which maybe the gas was the tenant's responsibility, but didn't that present a hazardous substance, which was your responsibility to
Well, there's two issues on this, Your Honor. First is, the question is whether it was a pre-existing condition as defined under the lease. Only then.
Violation certainly was.
Actually, no. There was no violation. What if I?
Wasn't a 2002 environment, or was it 2005 Environmental Control Board violation?
The 2002 violation was cured. The only things that are issued, if I can just say a couple things, Your Honor. There are on-point provisions, many in this lease, that says all gas issues are on tenant. Absolutely. And there's multiple provisions, and you can't rely on anything we said. You take it as is, and the only way
They
you
couldn't get gas service until you cleared the violation, right?
No, it's a totally separate issue. The 2002 violation was in a different space, not even the rented space in the building. What this was all about, if I could just explain, they tried to get out of this lease by an incident. This incident is what occurred in November 2018 when the tenant was trying to get the gas connected. Con Ed came in and they said there's a leak to a house pipe and a problem with part of the piping. So what happened was and Con Ed turned the gas off. Con Ed turned the gas off. So what they are alleging is there was some kind of gross negligence. The gas was turned off. The principal notified my client about this incident that the gas was turned off. So there was nothing to do. And in addition, we only would have to
Why
cure.
couldn't they get the gas turned back on? What was their problem in getting the gas?
Because all responsibility for the gas service was on the tenant by multiple provisions in the lease.
They rented this place. They wanted to open their restaurant. Why weren't they able to get the gas back on?
Because they
What
were
was the holdup?
incompetent. But there's 7 or 8 clear provisions in this lease.
But what
everything
was the holdup of
everything
their
was on the
getting?
tenant.
What was the holdup of their getting the gas back on?
They were incompetent. That's what it was.
What about the 2002 violation? Did that prevent them from getting the gas turned back on?
Absolutely not. It had nothing to do with gas. It was a violation from another part of the building that had nothing to do with the gas pipes. Nothing whatsoever. If I could just say this, there's a definition to pre-existing condition. We would only have to cure. It has to be a noted violation of a requirement, which is a law of the state or the city. There was never a notice of a violation of law. There was no pre-existing condition ever, and that's why we didn't have to cure. It's absolutely clear, Your Honors. There was no ever any pre-existing condition. But I just want to point out what they try to do here is get out of their lease obligations by exaggerating this situation with Con Ed where they said there was a gas leak, but it was turned off. It was turned off. And they told us about it, and we knew it was turned off. Everything goes back to them then because everything to do with the gas service was
Question
on the
becomes how
tenant.
and when you can get the gas turned back on.
That's their problem. This is a triple net lease. I'm sure Your Honors are all familiar with commercial leases. All responsibility for this gas service was on the tenant under this lease, under multiple provisions. It's directly stated over and over. They took the property as is. That's it. It was all on them.
Wasn't there an issue as to the reason that the gas was turned off was because there was some type of a leak in the pipe?
Of Con Ed, and this was in the affidavit of the principal of tenant. He admitted and told our client the gas was turned off.
Because there was a leak. Wasn't there a leak in the pipe?
But yes, but the gas was turned off, so there was no longer any leak.
Who's responsible for there's no longer a leak, but they can't turn it back on because they were given a reg tag or whatever, which would indicate that there's some type of potential hazardous condition if they turn it back on.
And that was then on tenants. It was not a pre-existing condition as defined in this lease.
But Counsel,
very
where
clear.
things stand at this point, the Supreme Court left us that there's going to be a trial. There are issues of fact about these very issues that you're talking about.
I don't think it is an issue of fact, because it would only be an issue, they say we're grossly negligent. It would only be an issue of fact if there was, in fact, an ongoing leak. Con Ed turned it
They
off.
say you're grossly negligent because they want to be able to amend to assert consequential damages.
Right.
But the other issues, there's still issues of fact. Who's responsible for what?
No, I don't believe it is, Your Honor, because it did not qualify as a pre-existing condition. It only qualified as a pre-existing condition that we would have to cure if there was a noted violation of law.
So Con Ed comes in and says there's a leak, and therefore we're going to turn off the gas.
They turned it off. Con Ed turned it off.
You would have only been responsible if Con Ed didn't turn off the gas if something happened.
I would only be responsible, we would only be responsible if, as a pre-existing condition, if it was a noted violation of law.
You keep saying that, so that's what I was trying to ask. So you say it's a pre-existing condition. How do we know that the leak was not pre-existing, was not there prior to them coming into the premises?
First of all, they took the property as is. It was not any ongoing condition because the gas was turned off. If I can just say one other thing, Your Honors. the other way that a tenant tries to get around these very strict lease provisions is by essentially amending their complaint through their briefs with new claims on appeal. Fraudulent inducement, there's no such claim. They make claims for statutory duties for negligence that was never made below. They make a claim for constructive eviction, never said below. RPL 223 with respect to rescission, never said below. The fraudulent inducement claim that plaintiff claims exists in the first, the tenant claims that exists in the first cause of action was never, the word fraud was never used below. This is the appellate counsel first brought up this idea of fraud was alleged in the first cause of action. The lawyers that actually drafted the complaint never said the word fraud once during the regular action. That was an amendment of their complaint. All these allegations, statutory allegations of a duty, fraudulent inducement, was basically an amendment.
The Supreme Court struck all of those causes of action but left the breach of the lease. Isn't there also an issue here that the gas service was registered at a different address, which the tenant didn't even know about, and therefore had trouble accessing and getting to a position where they could restore services?
Again, once the lease is
Isn't there then
signed.
an issue of whether and to what extent, I'm not saying it is a fact, I'm saying that there's an issue as to whether you cooperated with them in order for them to do what they needed to do in order to get the gas running.
Right, because you initially stated that the reason why, in response to my colleague's question as to why the gas was not turned back on, you said it was because of incompetence. So now, was there something in the record or an issue as to whether it's because of the issue as to the gas, the recipient or the owner or whatever being another address?
I mean, was it incompetence or your failure to advise them that the service was registered under, was it 87 Greenwich Street?
Right.
No, there isn't, Your Honor, because the duties, once the lease is signed, is all upon the tenant to get the gas going.
But
It's
you
not
had to
on our.
cooperate. But there isn't within that lease a duty to cooperate.
There is in parts of it. It does say it has to be willful that we didn't do it. There was no willful conduct.
Yeah, but these are all issues, right? All issues of fact.
I do really think that the biggest issue here is this one event where Con Ed was involved. This is blown up to be some terrible thing that we did.
I don't think we should use the term blown up.
It was turned off.
Thank you both. Thank you both.
It was turned off. Thank you.
Your Honor, may I respond to some of the?
No, you're finished, but thank you so
Thank you very
much. People v. Gideon, Godsent. Yes, you may proceed.
Good afternoon. Benjamin Rutkin-Becker from the Center for Appellate Litigation on behalf of Mr. Godsent Gideon, well noticed here in the audience today. I'd like to begin with the motive to lie point. In a case that hinged on the complainant's sharply disputed testimony, the court committed reversible error by denying the defense's request to instruct the jurors that they could consider the
Well, is
complainant's...
it reversible error? Why would it not be a harmless error? The general charge, which the court did give to the jury, was the general credibility charge, that they to make a determination as to any bias or motive to lie on the part of any of the witnesses. And it was within the general credibility and that the jurors should use their same senses, et cetera, in terms of judging the credibility of any witness, including any bias.
So I would just like to be precise about the error here because, Your Honor, you mentioned motive to lie within that. What happened here, to be very clear, is that the court excised motive to lie from the general credibility charge.
But there was a bias, but the charge still, the general credibility charge still talks about bias.
Correct, Your Honor. So there are other factors in the general credibility charge that were given here. And if anything, that only confirms the harm of the error because the court informed the jury that they could consider factors, for example, bias, interest in the prosecution, that really weren't at issue in this case. And as even the prosecution notes in their brief, motive to lie was a central part of the defense theory here, and the jury was never informed about that. And this is an instruction, as your honors are likely well aware, that is given in every single criminal case in this state. I cannot cite to a single case in which this charge was not given, let alone over objection. And so what the court did here creates a problem that really does not exist. And to say that this is not, the prosecution's argument now on appeal that this either was not error or not harmful because the jury was otherwise informed that they could use common sense, or again, as to credibility factors that really weren't at issue in this case, would just undermine entirely.
Well, didn't the judge tell the jury that they can consider whether the witness has any interest in the outcome of the case?
And gave the general charge as to an interested witness as opposed to a disinterested witness.
Yes, that's right. And there was.
Well, if the judge tells the jury you can consider whether it has any interest in the outcome of this case, it certainly puts you in a position to argue to the jury, which I presume you probably did, that there was an interest in the outcome of the case, and this provided reason for the witness to be less than truthful.
So the simple answer, Your Honor, is that
they weren't precluded from presenting this to the jury, and the jury was in a position to consider it.
Right, so that goes back to my question as to, is this really reversible error or whether it is harmless error? I mean, I think, as you stated, it's clear that the charge should have been given, but the fact that the charge was not given the fact that the judge did charge as to any bias, hostility, or some other attitude that affected the truthfulness of the witness's testimony, any interest in the outcome of the case, whether the witness had intentionally testified falsely as to any material fact, et cetera, that this gave the jury enough of an opportunity and a direction to scrutinize the testimony.
So the factors are all different things, and the CGI is written for a reason. And essentially what the prosecution is doing here on appeal is arguing that motive to lie within the CGI is superfluous. But
Not superfluous. I understand your argument. My question is, my statement is that it's not necessarily superfluous. Why would it just not be, again, that the jury is being told, hey, you know what, given all of these other factors in terms of bias, hostility, et cetera, there may be a motive to lie. She may have had a motive to lie. The two witnesses who testified may have had a motive to lie.
Right. So to first answer that question, I think at the end of the day, it's speculative to say that the jury actually considered motive to lie when, again, they were not told, as they should have been under the standard charge, that was a factor. That it's just not the same as interest in the outcome of the litigation, or bias, or demeanor. They're all separate things, and that's why the charge exists as it does. And as to harmless error more generally, there is the test outlined in Crimmins begins, it's a two-step test, and it begins with whether the evidence was overwhelming. We don't even get any further if the evidence was not overwhelming.
Okay, so why don't you address that issue?
Yes, Your Honor. Here the evidence was far from overwhelming. The jury was presented with marked significant inconsistencies in the complainant's accounts in the 36 hours following the incident leading up to Mr. Gideon's ultimate arrest. The jury struggled here.
Is there video evidence of the defendant in the hallway?
Sure, yes, there's video. It was not contested that he was in the apartment, and there were several different narratives, even under the complainant's accounts, shifting narratives as to what happened in that apartment. Her initial accounts fell far short of her serious allegations that she made at trial, which the jury hung on the top counts, acquitted him on the top counts, and convicted him of only a misdemeanor. That's nowhere in the prosecution's harm analysis in their brief. That's just simply not an overwhelming case.
Yes, you have time on rebuttal.
May it please the court, Alex King for the people. The trial court's jury charge and door opening rulings were a provident exercise of discretion.
Well, you do concede that the trial court should have given that charge in terms of motive to lie.
No, we do not concede that. The trial court reached the correct conclusion here, which is that giving that charge was unnecessary in the context of the entire trial. There is no doubt that the jury understood how it should evaluate a witness's credibility. The trial was replete with references to the victim's supposed motive to lie, and to quote the Court of Appeals, the jurors surely had sufficient intelligence to make the elementary logical inference from the charge that was given that a witness's motive to lie bears on
Defense
his...
counsel make that argument in summation?
I'm sorry, Your Honor?
The defense counsel make that argument in summation?
That the victim had the motive to lie?
Yes.
Yes, that was the thrust of his entire defense. So there is no doubt that the jury understood in this case how they were supposed to evaluate a witness's credibility. As to the missing witness charge, the request by the defense was not timely, given that it came nearly at the end of the people's case, notwithstanding that the defense had known about this issue for about 5 years. Defense failed to establish the control element because there was a bad relationship between the victim and the witness.
Well, the people ultimately produced a witness, right? The witness was there.
They did, but defense also failed to establish the availability element because the witness here, as was undisputed, was incredibly high, so he was not available to testify.
It was what?
He was incredibly high. That was the court's statement about his state of mind. He showed up to court reeking of marijuana, and that was undisputed by the defense.
But there was also an issue, was there not, in terms of what testimony he would have given and whether his testimony would have been cumulative or not?
Yes, I'm glad Your Honor raised that point because that is the most important issue here, which is that the witness's proposed testimony would have been entirely cumulative. There was no dispute that the victim in this case made multiple prompt outcries. All that this witness would have testified to is that the victim made a prompt outcry. Anything past that would have been rank hearsay and would not have been admissible.
But he was the first person that she telephoned, was he not?
That is correct. He was the first person the victim told, but the victim went on to tell several other people. There was no dispute that the victim made this call. And again, it was not disputed that this victim made prompt outcries. Defendant had any number of arguments available to him. This is not one that he chose to make. And for that reason, this witness's testimony, which again would have been about prompt outcry only, would have been cumulative. On the
And if he had testified, he would have only have been able to testify that she telephoned him. He would not have been able to testify as to the substance of what she stated.
Correct. He could have testified that she made a prompt outcry or that she had told him that a sexual assault had occurred, but that is as far as he could have gone. On the door opening issue, the defense proposed to conduct an incomplete and misleading cross-examination of the witness. Omitting mention of defendant's sex offender status would have left the jurors with the indelible impression.
We were talking about the notice of claim, right?
Yes, that's correct, Your Honor.
So there was information that the complainant had filed a notice of claim against the city because of the incident alleging that the defendant, who was a former sex offender, should not have been allowed to reside in that shelter, which was for victims of domestic violence.
Your Honor is exactly.
And what was the court's decision on that?
The court's decision was that the defense was welcome to cross-examine the victim about the notice of claim form that she had filed, but if they did so, it would open the door to evidence as to why she had filed the form, which is because a defendant was a risk level 3 sex offender that this domestic violence shelter had allowed to reside within. Giving the jurors the impression that she had filed this form because she was simply out for the money rather than that she was justifiably outraged that the defendant had been allowed to live in this particular shelter would have been dishonest, as the trial court said. Finally, there was compelling evidence of the defendant's guilt in this case, and relative to that evidence, defendant raises issues that are ultimately rather trivial. If there are no further questions, we ask that you affirm.
Thank you.
Going back to the motive to lie charge, the prosecution claims now that the court found it unnecessary. That was not the basis of the court's decision. The court found that there was no basis in facts for the motive to lie charge because the complainant outright didn't speak to a motive to lie charge. notably, this court has disavowed similar reasoning in Johnson and Santiago, and it's telling that the prosecution does not even attempt to defend it now on appeal. And in
What
fact,
would have been the motive to lie?
so the motive to lie, I think it was a very clear argument that was made by counsel. I'll get to that, and was very important to this case. There were different narratives that were presented. I mean, that's not really contestable. They were let in as prior inconsistent statements, and there was a, I would argue, more than reasonable inference that the complainant had escalated this account in order to obtain Mr. Gideon's arrest and, or particularly his removal from the shelter that they both resided in.
And this is based on what?
This was based on her, she expressed her dislike or discomfort by him. There are all sorts of things that could have occurred in the apartment, as we know that he was there on the video, short of anything criminal, consistent with her earlier statements that did not amount to a crime, but would well prompt, may well prompt a motive to get him out of the shelter and do whatever it would take to obtain that result.
When you talk about a motive to lie, you're talking about some type of benefit that's going to be obtained by the individual. So you're stating that the benefit was to get him out of the shelter?
That's correct. That was an argument that was central to Mr. Gideon's defense, that his lawyer made in summation. And the fact is, of course, summations are argument. It's still up to the court to instruct the jurors as to what are the proper things they can consider, as to instruct them to the law. So just because an argument is made by counsel, we can't say that it was considered when the court is telling the jurors, here are the factors, again, most of which were not actually relevant to the case of hand, that apply when you're assessing credibility, and motive is not included.
Well, that's not what the court never said motive is, you're not to consider a motive to lie, or there is no motive to lie. It's just that the court never used those exact words. Justice Mendez, you had a question?
No.
But, so the judge didn't give the motive to lie charge, and maybe he should have, or she should have, but the judge did tell the jury they can consider whether the witness has any interest in the outcome of this case, which we've been over. So that allowed the argument to be made and allowed the jury to consider it. And had they been persuaded, it would have been given them a basis to acquit.
I think interest in the outcome of the case is a lot different than a motive to lie.
Well, you stated that the argument was that the motive to lie was based upon a wish or desire for the defendant to be removed from the shelter. That seems to me to be the same as interest in the outcome of the case. That the interest in the outcome of the case, the interest is to, again, have the defendant removed from the shelter. But we've kind of, you have 2 minutes left if you wanted to address the other issues.
So briefly, one more note on harm on the charge issue. I would just like to point this court's attention to Johnson, which is a case in which this court found that not giving the standard credibility charge was reversible error. And the point there is that it was reversible error. This related to the falsus in uno charge, which I think in many ways is just as commonsensical as the motive to lie charge. It just says that if you find witness dishonest as to one fact, you can choose to disbelieve them. And in that case, it was reversible error not to give that charge precisely because that it happened to be a police officer's credibility was the central issue in that case.
Well, that case was different because the charge was not given at all. And the general charge, which was also given in this case, is that if you find that any witness has lied concerning any material fact, you may accept that portion of the witness's testimony that you believe to be true, or you may disregard that portion or disregard the entirety of the witness's testimony. So, I mean, that charge was given, and that's a little different from Johnson.
They involve different credibility factors. That is true. There is a list in the general charge, as I'm sure you're well aware, of the factors that are relevant to credibility. Falsus in uno is one, motive to lie is one, and Santiago and Johnson, which both apply to falsus in uno specifically, are just as applicable here. To hold otherwise would really lead to an uncertain, I would submit, nonsensical result.
Well, again,
where
assuming that we believe it to be harmless error and not reversible error, did you wish to address the other issues?
I'll briefly address the missing witness issue, I think the core of the court's decision below did come down to the cumulativeness. There is a specific standard Smith lays down. That's a 2011 Court of Appeals case. Evidence is not cumulative in the missing witness context when it would add to or contradict the prosecution's
What,
case.
if anything, is the fact that the witness was in court and you were free to call the witness? Does that count for anything in this analysis?
It does not, Your Honor. It actually means that this witness was available to the prosecution. The missing witness charge exists precisely because of situations like this, where a
Other
prosecution...
than saying that there was a prompt outcry, what was this witness going to add?
So, two things on that. I have a legal answer and a fact-specific answer, if you'll allow it. I submit that under Garcia, which is a Fourth Department case applying the Smith standard in 2021, we urge you to look at that and to follow that. And just the fact of testifying to the prompt outcry would, under the Smith standard, render this not cumulative. Of course, the prompt outcry rule exists because
There was already testimony for prompt outcry.
Right, and so what I was going to say, Your Honor, if you'll permit it, is that the rationale for prompt outcry rule, and this is what Garcia and the Fourth Department held, is that this is supposed to be at the first suitable opportunity. So when you're talking about an additional, more contemporaneous prompt outcry witness, that would add to the prosecution's evidence under Smith and is not cumulative. I will also note, in terms of the facts of this case, defense counsel pointed out that, of course, there were other prior inconsistent statements that were elicited throughout this trial. And had defense counsel been able to, been earlier provided this witness's information and been able to interview him, it could have changed the way that he cross-examined the complainant in order to elicit prior inconsistent statements from this witness. So for both of those reasons, an adverse inference charge was required here.
Thank you.
Thank you.
Both. Menino versus Waldorf Exteriors. Menino versus Waldorf Exteriors. Yes, whenever you're ready.
Good afternoon, Your Honors. May it please the Court. Beth Gehrig of counsel to Morgan, Levine, and Dolan for plaintiff appellant. We present here, Your Honors, a classic 240 case involving a falling object. The issue here doesn't seem to be whether it is a 240 case, but rather whether the intended target defense was available to the defendants to negate their liability. We submit that the trial court got it wrong here, both on the facts and on the law. Factually, it couldn't have been the area which fell. We're talking about a column that had 3 tiers. The area which fell on the plaintiff was the middle tier. There is absolutely no question about that. A piece of concrete approximately 200 to 300 pounds.
Had he worked on that particular segment of the column?
Absolutely not, and that is uncontroverted. The only thing he had worked on was the first tier. After he worked on the first tier, he went down to the ground. He was cleaning up the debris from the chipping that he was performing. And while he was on the scissor lift on his way back up, he had not yet begun work. He hadn't even reached the location yet. So you can't have an intended target if you actually didn't get to, we'll call it the work site at the point. The work site here being the second tier of that column. Since he had not yet reached the tier, he could not have yet started the demolition. He was not using the chipping gun at the time. Therefore, it could not have been the intended target. Case law from this court makes it perfectly clear that even when the ultimate outcome is supposed to be for that portion to come down, if the work has not yet begun on that area, then it cannot be the intended target. We cited in our reply to Hyatt involving both scaffolding, tower scaffolding, and reshore scaffolding, both that were being dismantled at the time. One of them came down, but because that was not supposed to come down at the time, even though eventually it was supposed to, It was not the intended target, therefore the 240 claim stood.
What did did any of the defendants do to prevent that specific section from falling on the plaintiff?
Absolutely nothing, Your Honor. They were on notice after the RFI that there was a problem. It was so bad that 2 trades were going to actually walk off the site unless it was fixed. Meetings were held, walkthrough was held, and it was determined that this was a problem, this was a hazard. They decided to do nothing. Employers, owners of property, GCs, construction managers, people charged with site safety, they're supposed to protect the workers. They knew that this was a hazard. They knew that this was a significant hazard. They did absolutely nothing. We believe not only was it wrong for the trial court to deny our 240 motion for partial summary judgment and our motion for partial summary judgment under 241-6, we think it was even worse that they dismissed these 2 claims.
Are Waldorf and Calvin statutory agents?
I'm sorry?
Waldorf and Calvin, are they statutory agents here?
We would argue they are, Your Honor. And,
Why?
well, notably, with all due respect, those were decided against the defendants, and the defendants did not file cross notices of appeal. However, I did take down some notes just in case you wanted to know. As far as TDX was charged with site safety. There was testimony from the FIT's witness that they were able to stop the work and that they were charged with site safety. As far as Waldorf, they created the hazard. They're the ones from their demo work starting back in the spring that actually created this hazard, and they were charged with basically the ability to control the activity that actually brought about the hazard that caused the injury.
So you're saying that Waldorf created the issue?
Absolutely, and the testimony is clear. When they were there, what happened is when Waldorf came on board, they were first taking off the veneer, off the columns. There's the decorative veneer on the outside. And as they're taking off the veneer, there started to be problems, and there were pieces of the debris, the inside cement falling down, the fireproofing that was around the structural beams. That's when several of the other trades said, my guys aren't going to work here, they're going to get hurt.
Is it your argument that because they created this issue that they are now statutory agents?
It is our argument because they had the ability to control the activity that brought about the injury under
When you say that they had the ability to control the activity, what do you mean? They had the ability to not cause this issue? Or because on the date that this incident happened, weren't Waldorf and Calvin, they were not on site. They had not been on site for several months. Is that right?
Well, Waldorf came back. Waldorf was back. There was a job ticket for October, and they were back on site. They were performing work. They were asked to enlarge the pockets that were there, but because they created it and they had the ability to put up the netting, to put up the shoring, to put up the very protections that should have been there to protect the workers, and they didn't do it, that yes, they are vicariously liable as a statutory agent.
Is there anything in the record that supports your statement that Waldorf created the incident or created the columns? Because I thought they supervised. I thought it was that they supervised the columns or the demolition of the columns, not that they actually took part in it.
No, Waldorf is the one that actually did the original demo. Waldorf is the one that came in and they were removing the veneer, and then they were asked to come back. There were the 2 job tickets.
What about Calvin?
I'm sorry?
Calvin. The same thing for Calvin?
No,
They were the maintenance company on the project?
Right.
yeah, I believe when they answered, Waldorf answered for both of them, and Waldorf put in their argument for the 2. I have to be honest, I'm not as familiar with Calvin, just as far as with Waldorf and what all the testimony was with Waldorf. I don't think they were separated out in the 2. But again, they did not, these were findings that were made against them. They did not file the separate notice of appeal. However, when you had asked for the dates, we have the work tickets. The work tickets are on the record. The first one is January 23rd, 2017. The pages of the record are 859 to 860, 863, and 697. And then we have the work ticket from October 3rd, 2017, showing they're back on site in October. There was testimony about it, and the work ticket is in record, pages 866 to 867, and 708 to 709.
Thank you.
Thank you.
You represent Waldorf.
Yes, good afternoon. My name is Bashir Masani for respondents Waldorf Exteriors and Calvin Maintenance.
Are you a statutory agent?
No, we're not a statutory agent in this case. Waldorf was not on the job site and was off the job site 6 months before.
Also, can you put the mic closer to you, please?
Waldorf was off the job site 6 months before.
Why isn't what you did 6 months before capable of making you a statutory agent?
Sorry, what was that?
Why isn't what you did 6 months before something which could make you a statutory agent?
I'm not sure that it would make us a statutory agent.
No, but I mean, in terms of deciding this as a matter of law, as opposed to leaving it as an issue of fact for a fact trier.
Because Waldorf didn't create the condition. The plaintiff testified that after Waldorf left the site, iron workers were working on the same column, welding and bolting steel.
But isn't the claim that whatever you did 6 months before is what made possible the cement falling now?
The cement didn't fall down for months after Waldorf was off the site, so I'm not sure that it could be pointed to Waldorf's work.
So are you saying that because it was 6 months later, that whatever work was done, it could not have been contributed to the columns falling 6 months later because it was 6 months? There's a cutoff?
Correct, because other trades were working on the same exact column.
I mean, we should make that finding as a matter of law.
Correct. This is also distinguishable from Ty versus Hennigan, which plaintiff cited, where the demo contractor was found to be a statutory agent. In that case, the demolition contractor was actively performing demolition work, and the first department found.
So how do we say as a matter of law, because you left 6 months before, that nothing that you did during that the prior 6 month period could have contributed to what occurred, the demolition issue now in terms of columns falling? How do we say that as a matter of law?
Because Waldorf didn't have the ability to control the activity that occurred 6 months later when plaintiff was injured.
You didn't have the ability to control that?
No, Waldorf wasn't on site 6 months later.
Do you have to be on the site in order to be able to control that?
It wasn't Waldorf's call to put any bracing or shoring. That would have been on the construction manager or property owner, as the statute intends.
Thank you. So you represent TDX?
Good afternoon, may it please the court. Sim Shapiro from law firm of Strakowski, Drachman and Shapiro on behalf of the defendants, third-party plaintiffs, respondents, TDX. Not every day that I agree with plaintiffs' counsel on a labor law 240 case in this jurisdiction, but I do agree here that in fact, insofar as not only it's really undisputed that in fact this was caused by Waldorf, and one of the things I'll point out is if Your Honors look at the decision from the court below, my client was granted contractual indemnification without opposition by Waldorf.
So Waldorf says they were gone 6 months before. There were other trades that were working on the columns, and that they had no further control over the columns.
I think and I believe it was Justice Friedman who pointed out that the ability to control the instrumentality of the work makes one a statutory agent. And in fact, that is the case here because it was their work, it was their demolition that caused this condition. That was the plaintiff's testimony, really unrefuted. Again, to concur with my colleague, plaintiff's counsel on that, insofar as there's really no dispute here as to what was the cause of this particular instrumentality. The fact that someone goes off of a work site doesn't mean they're no longer in control and they've got nothing to do with it and they wouldn't be a statutory agent just because, for whatever their reasons were, they left. So long as they control that instrumentality, that would in fact make them responsible for that instrumentality statutorily and otherwise, for that matter. You know, the idea of saying, oh, well, we left, so now it's not ours, there's really not a basis.
Well, not only we left, but we left six months ago. So does that go into your argument at all?
If you cause a condition or you control an instrumentality, you cause a condition. And I'll add, just because you're not there doesn't mean you lose control over it. In other words, hypothetically, you could come back and, unless you're barred from the work site, to say, look, I caused this condition, it's my instrumentality, but if I walk away, it's no longer my instrumentality. I don't think that's the way the law works in terms of Labor Law 240. Again, just in terms of causing a condition. If someone, by analogy, someone were to cause a condition on a sidewalk, whether it be a snow or a crack or whatever it might be, it's no longer their condition simply because they left. However many days it was, I don't think that would be the distinction there.
But what about your client, TDX? Why isn't TDX a statutory agent?
Well, actually, they're a construction manager here, and I actually disagree with my colleague on behalf of Waldorf, which is there's a general contractor here, and there's a distinction between a general contractor and a construction manager.
Oh, I'm aware.
General contractor, yes. So there is a distinction there, and when you have a general contractor, it's the general contractor. And by the way, it's the general contractor, Vanguard, which is the plaintiff's employer, that hired Waldorf. And I might add, it's Waldorf. The plaintiff, I think, even said he even was responsible for the safety and the work that Waldorf was doing. So again, there's that connection as well to Waldorf. There's a very clear distinction between that and what a construction manager does.
Right.
And the fact that the construction manager, could in theory have stopped the work is not the same as being the general contractor that's actually responsible for the overall safety of the work site, hiring the subs, coordinating the work, coordinating the trades, and again, specifically hiring, in this case, Waldorf.
But how do we deal with Mr. King's testimony? I believe he was the deputy director of facilities from FIT,
From FIT,
right?
yes.
And I believe Mr. King testified that your client certainly had the authority to enforce the safety measures as well as to stop unsafe work practices. So how do we deal with that?
Not the same, having the authority, not the same as actually being the one that does that. And again, there's a distinction there. And especially, I'm aware of there's a body of case law where it comes to construction managers, but that's when there is no general contractor. When there is a general contractor, and that's the entity that's responsible, that's the statutory agent. And in fact, that would be the case here. And I do appreciate that I'm out of time. I will rely on my brief, other than to say just very briefly, in particular, we want to point out that given the nature of the work here, because the plaintiff, I think there's a distinction there. Hyatt was the case that was referenced by my colleague. This is a little bit different because the plaintiff testified, I think it's on page 357 in the record, this is the very same column. To draw a distinction, well, it's a few feet down as opposed to a few more feet down, somehow that's not the work that I was doing. I would say there isn't a distinction, and that's why this is so much like Moncayos and other cases like that, where it's the very work that this plaintiff was doing, and therefore not a Labor Law 240 case. Unless Your Honor have further questions for me, I'll rely on my brief.
Thank you.
Three points, Your Honors.
So did you want to address the point just made by your friend in terms of the column?
I did want to address that one first.
Okay.
If we look at if we look at the case involving the demolition of the roof bay by bay in Ragabir, 146 AD 3D 563. Again, the roof was coming down, but they were going bay by bay. Here too, even though the fireproofing concrete was going to come down, they were going tier by tier. He had not yet started working on the middle tier. Even Salazar, when it cites to Walensky, makes it clear that it has to be the work that they were doing at the time. And here they had not yet reached that location. He wasn't working there yet. So as I said, it was like he was traveling to that location, albeit by the scissor lift, but he had not yet reached the location where he was going to be doing the demolition. There is absolutely no reason why it couldn't have been shored, braced, netted or something, and once he got to that level, then he would have been able to remove the bracing and begin it. They knew that it was a hazard. They knew it was coming down. They didn't protect him from it before he even got to that location. As far as TDX, I think one of the things that's important to note here is who moved for summary judgment when. Plaintiff moved for summary judgment first. For the TDX to say that they were not, that they didn't have any responsibility for safety, they had to make a prima facie, sorry, for them to oppose it and say that they did not have any responsibility for safety, especially in light of King's testimony, they needed to come forward with something. At best, they would have raised a question of fact. On their motion, they didn't submit the construction agreement. How could they show what their duties were with regard to safety if they didn't make the prima facie showing? And in response to that, we provided the testimony for King, which raised a question of fact. I believe at this point, Your Honor, my time's up, and I want to thank you very much for your time.
Thank you. Thank all of you. McNaughton v. 5 West 14 owners.
May it please the court. My name is Neil McNaughton. I'm the plaintiff appellant pro se in these 6 related appeals. Any questions the court has? There's so many issues in these appeals that any questions the court has, just please jump in and ask. I'm only going to deal with 2 issues in my main talk, and then I will reserve the question of my default and the delay in the
You have 2 minutes in rebuttal. So you have 5 minutes, now you
Right.
have four minutes,
gonna-
4.5 minutes, and then you have 2 minutes in rebuttal.
Right, and I'm going to postpone the talk about the delay and the default until the 2-minute period after my adversary has given her speech. I'm
Excellent.
going to talk about the other 2 issues I want, which is the blatant errors in the granting of motion sequence number 3, which is 04408, appeal 2021 04408, where basically I showed, I think convincingly in the papers in the lower court, that prior counsel for the respondents had lied to the court. I mean, said I had agreed to allow them to respond to file a late answer when I had never. I had agreed to negotiate that week, and I specifically told the paralegal, and this motion was made on the basis of an attorney affirmation with absolutely no knowledge of what happened. I was dealing solely with the paralegal. I told the paralegal specifically, I'm willing to grant you an extension of time to answer, but I will not grant you the extension to make a motion to dismiss. And when I got the stipulation that she sent, what she said I agreed to, it did not make that distinction. And luckily, because I was a lawyer, I realized that even though it didn't especially say that the defendant would have the right to make a motion to dismiss, the way the stipulation was worded, that would have been the effect based on how these things are viewed by the courts. So at no point was there any agreement. The prior counsel for the co-op defendants, respondents, blatantly lied to the court in order to get the court to agree to that, to agree to the extension. And I believe in the papers below, I showed pretty clearly that she was lying. I mean, you can look at the papers and you'll see. The second question I would like to address, of course, which is very important and usually would not be granted, is the motion for recusal. I think I made it clear in the papers the many times the court departed from proper practice.
I'm sorry, you made a motion to have the judge recused?
Excuse me?
You made a motion to have the judge recused?
Oh, absolutely. You haven't read the papers?
And I did not see that, I apologize. So was that denied?
She said it was moot.
And so did you appeal from that?
I absolutely did.
Okay. And what was the basis for your motion for recusal, for her to recuse herself?
Well, I have
The short answer?
in the record,
Reader's Digest?
yeah, in the record, 621, I thought I had it written down. But there are in the motion in the court below, I list on paragraph 41 in the motion 10 separate actions by the court that I thought were completely erroneous.
Okay, so this was November 28, 2023, where the court denied your motion for recusal.
Yes. And I don't, you know, the court, I assume that I put in the record all the problems, you know, obviously the fact that the court records, the official court records disappeared. There's a number of malfeasance by Supreme Court clerks. You'll notice that in my papers, it says, and for recusal, the clerk, for example, who entered this for me, didn't put recusal, and I believe an administrative judge, if they'd seen that in the title, might have actually done something at the lower court level. I don't know. I've read something about that. But the judge, I mean, all you have to do is look at motions numbers 1 and 2, which is 04395 and 04406, and it's clear. I mean, she says for the reasons granted, she's dismissing my claims against. They didn't appear before this court, but against the attorney defendants, and they didn't give any reasons in their papers, and you can see. I don't know why the judge did not try to actually write an opinion, but maybe because if you look at my papers and the adversaries of the papers, because it was very hard to write an opinion on that basis that would actually justify her decision.
Thank you. You have time on rebuttal.
Thank you.
Good afternoon, Bianca Baez, Allen B. Berlin Associates for Respondents. I just want to start with regard.
Counsel, if you could just keep your voice up, please.
Sure, sorry. With regard to the motion for leave, plaintiffs or appellant states that the record shows that the prior counsel for respondents was lying. If you look at the record, there are emails between the appellant and prior counsel.
Well, your friend states that he never consented to an adjournment or
Right.
to additional time.
Yes, there is emails that state that they were in communication with regard to an extension of time, whether or not it was to answer or for a motion to dismiss. That's a miscommunication. But there are emails saying that he revoked his consent and therefore prior counsel made the motion for leave. I don't think that that motion was improper at all. There were obviously communications that there was an intent to seek a motion to extend. And there is no basis in the record to state that the decision of the lower court was improper. With regard to any other appeals, I apologize, but appellant didn't address them, so I would like to rely on these submissions.
Whatever you wish to do. You want to submit on the rest, on the remainder?
Yep.
Okay, thank you.
Your Honor, with regard to, unfortunately, I don't have a laptop, so I don't have the record with me. But with regard to that simple question, if you look at my, my brief, I specifically quote an email from the paralegal, and as I said, the attorney never spoke with me. Well, we did speak, I think, for a bit, but she never negotiated with me. And I have a quote from an email from the paralegal, and it's on page 25 of my brief, where she had sent me a stipulation. We were in negotiations, just the way people do. I had said, this is not sufficient. You didn't properly distinguish between motion to dismiss and answer. And I sent back a counter stipulation. This is the response. The Eustace paralegal Rose Bianco in her email to appellant dated April 6, 2021. In response to appellant's email, April 6, 2021, stated in pertinent part, thank you for providing the revised stipulation, which was, of course, never agreed to. I am CCing Mrs. Frankel, who's the attorney, herein so that she may review the stipulation and advise as to approval or suggested revisions. Now, that's clear that we're still in negotiations about a stipulation or an agreement. I mean, the lawyer just lied about it. There was never any agreement. We were negotiating about a stipulation. She specifically disobeyed my explicit instructions that make a distinction. I will grant you an adjournment to answer, but not to make a motion to dismiss. And that's where it ended. And then she, instead of dealing with me and actually negotiating, she just applied to the court. And her note, what's the application of good faith? This is dated April 6th, and Frankel's affirmation of good faith, which is on A429, is dated April 7th. So we're in the middle of negotiations, and all of a sudden she applies to the court and says, hey, we made good faith negotiations. That's not the way things work.
Thank you. Thank you.
Thank you.
Baskerville v. New York State Office of Children.
Good afternoon, Your Honors. Joshua Cohen for the state respondents. May it please the court. The petition here should be dismissed for lack of personal jurisdiction because petitioner never served the Attorney General. Petitioner has never disputed this, and because the Office of Children and Family Services is the only proper defendant in this case, his failure should result in the dismissal of the entire petition. Unless the court has any questions on the service issue, I'd like to spend the remainder of my time briefly addressing our alternative argument.
We should also be dismissing as to ACS, right?
Correct. Their position, and they've submitted, is that they're not a proper defendant.
But you're representing ACS as well? No.
No, Your Honor. I'm representing the state respondents, Office of Children and Family Services, and which is actually the only state respondent. The statewide central registry is not a separate entity from OCFS.
But you were not properly served?
Correct.
Okay. Thank you.
Thank you, Your Honors.
TCS Construction versus AmTrust North America.
Good afternoon, Your Honors. Max Gershwire for the appellants, AmTrust and Wesco. The lower court erred in denying Wesco and AmTrust summary judgment. The Wesco general liability policy does not cover TCS based on the policy's employee exclusion because the evidence establishes as a matter of law that the underlying plaintiff, Mr. Pacheco, was injured in the course of employment with TCS. He testified under oath to that effect and collected workers' compensation benefits for the accident as TCS's employee. In fact, TCS did not even argue to the contrary in the lower court and contest the issue now only because the lower court found a triable issue of fact. But to raise such a triable issue of fact, TCS was required to submit an affidavit contesting the issue, something it never did, even though, of course, it would have personal knowledge about whether or not it employed Mr. Pacheco.
Had he been employed by his brother, as was alleged, as an independent contractor, would the result have been the same?
Yes, Your Honor, because the policy also includes an independent contractor's exclusion. The only reason why we didn't raise that in the motion papers below is because there was no issue, there was no dispute about whether he was an employee. But we did raise the issue here that the lower court erred because even if it found that there was some issue as to whether he was an employee or an independent contractor, either way, there's an exclusion that deals with that. So it should have been found that there was no coverage under the general
Still
liability.
have an issue as to grave injury?
Not according to the bill of particulars and the deposition testimony. Minor injuries to the hand and to the back. The only grave injury that plaintiff claims may be at play here is loss of use of a hand or permanent and total use of a hand, loss of use of a hand and arm. Here you have a hand injury that didn't even require surgery, and you had deposition testimony that's in the record that says that even after the accident, the plaintiff continued to work, and to the extent that he claimed that he couldn't do so in the future.
So therefore, they can't go after you under the employment liability policy.
I'm sorry, Your Honor?
Therefore, you are not subject to liability under the employment.
That's right. There's only coverage under the employer's liability
the
policy if there's a grave. Right.
Workman's comp bar, which could have been overcome by the grave injury, but since there's no grave injury, you say you're out.
That's correct, Your Honor.
Thank you.
Thanks, Judge.
Good afternoon, Your Honor. Salvatore Compaci appearing for Sinaskaya and Univer on behalf of the appellants, defendant appellants.
How do you get around?
Plaintiff's respondents, I'm sorry.
Counsel?
Your Honor, I apologize. It's late.
How do you get around the fact that he collected workers' compensation as an employee of TCS and that he stated in his bill of particulars that he was employed as a laborer with TCS?
Well, Your Honor, I think it's still a question of fact, which goes to a basic argument here. That was a question of fact whether or not he was an employee or not, or whether he was an independent contractor.
What's the issue of fact? If he was an employee of Carlos Pacheco, so that's an independent contractor, and the policy doesn't cover an independent contractor.
It would not. It would not. However, once
And if it's not an independent, if he worked for Vanguard, so then the liability arises from the fact that TCS is having to answer for the liability of another, so there's an exclusion for that under the policy. And then under the employment liability policy, there's no grave injury, there's no coverage, right?
with respect to grave injury.
So what's the issue of fact?
Well, the issue of fact regarding grave injury is that he does claim that, and this is under Workers' Compensation Law Section 11, that the appellant focuses on permanent total disability, but under the statute, it could be permanent total loss of use of an arm, leg, hand, or foot. Look at his bill of particulars, he is claiming that with respect to the injury to the wrist, as far as grave injury.
I thought he had a fractured wrist.
Fractured wrist.
Is that a grave injury?
That doesn't constitute grave injury.
Well, he did claim his bill of particulars that he wasn't able to work, so that would go to the permanent and total loss of use of it. So we believe, but once again, I think that's a question of fact. And I think a lot of this turns on the fact that the appellant has decided, well, it's not a grave injury, but it's the lower court held, and we agree that it is a question of fact whether or not it does meet the definition of a grave injury under the statute. Also, with respect to, just to swing back to the...
Are there any cases that state that a fractured wrist constitutes grave injury? Because I thought the cases stated that that does not constitute grave injury.
Well, Your Honor, a grave injury, but it goes to whether or not there's a permanent and total loss of use. That could have been a fractured wrist or any injury where it results in a permanent or total loss of use of a limb like an arm or leg or hand or a foot our argument is, under the definition of Section 11, would meet that definition of a grave injury.
Was there anything in the record that stated, including with workers' comp, that because of this fracture to the wrist that he was precluded from working?
I believe it's in his it stated that so in his bill of particulars that he couldn't work. That's what we're relying on. At the moment, I don't have any specific.
But doesn't grave injury require a permanent total disability, which only applies to acquired injury to the brain caused by an external physical force, which results in unemployability in any capacity? Isn't that what the Court of Appeals said in Roubaix versus Aqua Club?
Yes, Your Honor.
So how do you get past that here?
Well, once again, will rely on the wording of the actual statute of workers' compensation law, section 11, which once again, not to be redundant, but goes to the.
Talks about things like amputation of an arm, leg, hand.
I think total loss of use, or I think it's in addition to amputation. I don't think it has to be an amputation, not to be a permanent total loss of use of that particular body part.
No, but then it goes on to talk about unemployability, and there's nothing here in terms of unemployability because of the injury to the wrist.
Well, once again, Your Honor, I think that still would be a question of fact for a jury or trier of fact to decide.
But you need something like an amputation of an arm, leg, hand, a foot, loss of multiple fingers. You don't have anything like that here.
You have a healed fracture.
Our contention is that a fracture would be, as long as it's a resulting permanent total loss of use of that limb. In this case, I guess would be a hand and an arm, or one or the other. That would
I just want to go back for a second. So the plaintiff is saying, he couldn't work because that was because of the wrist. Am I right about that? The wrist?
Yeah, along with his other injuries, yes.
Because I thought it was the back injuries, and that's like soft tissue.
Correct, Your Honor. There was additional issues that's listed in this,
Radiculopathy and
as well as particularly the back. Correct.
no surgery with the back, right? I'm looking at the bill of particulars.
Thank you.
Disc bulging. Everybody has a disc bulge.
Thank you.
Thank you.
Your Honors, if there are no other questions.
Thank you.
Thanks.
Echo Engineering versus Locust Solar. Well, somebody, anybody?
Be happy to. Good afternoon. Thank you for the court's attention. My name's Harry Nicolay. I represent the appellants. I'm with the law firm of DeBello, Dinellen, Weingarten, Wise, and Whitaker in White Plains, New York. We're here. I think it's relatively straightforward issues where the court below rejected my client's usury defense.
You have 5 commercial loans totaling $3.75 million, right?
That's correct.
They're individual loans.
They are all separate loans, Your Honor.
Okay. So how do what you did was you stacked them, right? So that you came up with an interest rate higher than 25%, right?
I don't understand your question when you mean by.
What is the basis for your argument that this is usurious?
Because if you look at, first of all, that was where the court made the first error. We submit that the contract rate and the default rate run concurrently. The court concluded that.
The default rate create usury?
That's where we say the second issue is. I say that the default rate is within the scope of the criminal usury statute. A lot of the cases that are relied upon by the court and relied upon, by the court below and my adversary are using civil statutes, which I believe are significantly different in light of the last Court of Appeals case to rule on these issues, the Adar Bays case. But
the default rate only applies after maturity. Is that correct?
After when?
After maturity. It would only be applied after maturity, correct?
The default rate applies upon a default.
Right.
And if you read the language of the.
But a default is you can avoid a default by paying the loan. So I'm not understanding how, again, you figure that into the calculation.
Because we submit that the case law allows the two to be run concurrently, and that the.
But if it's a default rate, what did the Court of Appeals say about that in Eikenberry? Didn't if it's imposed only upon default?
I mean,
What did Eikenberry say about whether that?
that's the argument. The argument is that my clients could have avoided the default by paying the loan. It was within their control. But the first department,
So doesn't Eikenberry?
I believe Eikenberry has different facts and was.
So why shouldn't
interpreting a
Eikenberry apply here?
I believe it was interpreting a civil civil usury.
Even if that's so, why wouldn't that reasoning apply in the criminal context?
Because the criminal usury statute is a little different than the civil usury statute. The criminal usury statute is Section 190. The civil is general obligations law. And two things. The statute just uses the word interest. It doesn't distinguish between pre-default, contract rate, default rate. It just uses the word interest. And really importantly, the ADAR base case, it says, in determining whether a loan is usurious, interest needs to be construed broadly. And
but to get to your claim of usury, we have to accept that Section 3B of the note, which appears in all of the notes, is to be stacked upon Section 1A. Why should we interpret the contract in that way? Doesn't Section 3B apply what happens if there's a default? And it doesn't mean that you take the 8 or 10% which you've been paying all along and add that to the default rate that's in 3B. Doesn't 3B come in and say, well, if there's a default, this becomes the rate?
I believe, and I have my chart here highlighted, Section 1B, which is the contract rate, first of all says the principal amount shall accrue until paid in full. So that's going to continue even after a default. Number two, Section 3B, the default.
That also could be just as easily interpreted as applying until there's a default. If you're going to pay off the loan, you have to pay interest until you pay it off. It's not talking about what happens when there's a default.
It does. Section 3B does.
But 1A does not talk about what happens.
3B references the contract rate, and it says, upon default, after default, entire principal balance remaining unpaid hereunder, as well as any amounts due and owing under Section 1, meaning the contract rate, shall bear interest at the default rate of 25%.
Also here, in fact, after the default, the interest rates were not stacked in practice, correct?
It was in excess of 25%. I say they were, because it included the 25 and the 10, and they ran concurrently.
Is that what they charged you? Is that what they're saying is owed?
Now, in fairness, they're not charging that, but under the case law,
Right, they're charging the default rate of 25%, right?
I don't really know exactly what they're charging, all right?
So we'll ask them when they come up.
Thank you. You have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Melissa Pena from the law firm Norris McLaughlin on behalf of the respondents.
So to get to the heart of whether, in fact, this has what could be called a criminally usurious rate, how do you deal with what your colleague was pointing to in Section 3B, as well as any amounts owing pursuant to Section 1 and 3A of this note? What does that mean? Why doesn't that mean that you're charging a rate above 25%?
Right. Why is it not stacking? Why are you not adding an additional interest rate?
Well, we're relying on the first sentence of Section 3B, which says that notwithstanding anything else contained herein to the contrary, upon maturity or upon default, the rate increases to the default rate. So my colleague is saying that paragraph 1 states that principal accrues on the loan until paid in full at the contract rate. Notwithstanding anything contained therein, inclusive of his language that Your Honor indicated could be ambiguous, it states, notwithstanding that language, upon a default, we are permitted to charge the higher rate of default interest of 25%. That's why this was interpreted by the lender, as well as the lower courts, as not to stack the interest rates. And the record is clear that that is not what the lender did in this situation. The lender, from the time the loan originated until the maturity date, the lender charged the note rate, the contract rate of interest, which I believe was between 8 to 10%. Once the defendant's default, the lender charged default interest, a rate of 20 to 25%.
Let's try to take a concrete example. Let's say you owe $100 and the interest rate is 10%. Money is due December 31st. At 10% interest means that you're supposed to pay back $110. You don't pay it back, you're now in default. So what happens at that point?
At that point, the lender's entitled to collect $110,000, and interest will accrue on the $100,000 at the default rate of 25%. At no point will there be stacking with the default rate being added to the contract rate.
What about the fact that you owed $110 on December 31st before you got to default? What happens to that $10,000 that would have reflected interest?
Our position is, and the position taken by the lender here, is they did not charge default interest on that $10,000 of accrued interest. And we would also respectfully submit that as a matter of law, we think the law is clear that the criminal usury statute does not apply post-default. While I'll acknowledge that the Court of Appeals has yet to precisely rule that the criminal usury statute does not apply post-default. As Your Honor noted, in the Eikenberry decision, the Court of Appeals found that the civil usury statute does not apply post-default. And the rationale by the Court of Appeals was that a loan obligor can control whether there's a default under the loan. And there's no basis why we would hold consumers to a standard of holding them responsible to their default and not hold corporations to the same standard. And in fact, they rely heavily on the Madden decision by the Southern District of New York. The majority of district courts that have decided this issue have found that the criminal usury statute applies post-default. In addition, the sister court, the Second Department, has repeatedly found that the criminal usury statute does not apply post-default. And at best, I can see Your Honor's a bit troubled by the interest calculation. This is not usurious on its face. At best, there's an ambiguity. And there's an ambiguity because that's not how the lender interpreted it. That's not how the lower court interpreted it. I note that this provision was drafted by the defendants who provided us with a form loan document. Any ambiguity should be construed against them, and there's no provision in the contract that states otherwise. Further, when there's an ambiguity, there has to be evidence of usury. They've submitted no evidence in the record for that evidence. No evidence in the record. The only evidence in the record is that this lender never charged a rate over 25%. The evidence of the record occurred that happened with these 5 loans, as well as 11 other loans that they paid off. All of these loans aggregated among about $6 million. While I appreciate that they were separate loans, so the usury statute still applies, this is not the type of parties that the usury statute, as a matter of public policy, was seeking to protect. And we also provided them with monthly statements post-default showing them that we were charging default interest and we were not stacking the rates. That's the only evidence in the record.
Is that in the record also, that you provided monthly statements showing it was 25% and not 33% or 35%?
Correct, Your Honor. It's attached to the Kirkpatrick affidavit that was submitted in support of our motion for summary judgment on reply.
Thank you.
Thank you.
So I have a few things I'd like to say.
I want to take you back to my hypothetical. You borrow 100, so comes December 31st, you're at 10% interest, you owe 110, right?
Okay.
Right. You don't pay. So what happens now? I mean, you're not going to start charging, comes January, February, March, the rate becomes 25%. 25% of what?
25% of the entire unpaid balance, and the 10% continues to run because the language, the clear and unambiguous language in these, you read these provisions.
No, but as well as any amounts owing pursuant to Section 1 and 3A.
And one continues until paid.
On December 31st, you didn't owe 100, you owed 110. You had use of that money for the year.
I'm not following exactly the math, Your Honor.
That's why I took a very simple example.
I understand.
Because I wanted to be sure that I could follow the math too. You borrow 100.
It's round numbers.
I'm not getting your point.
You borrow 100, 10% interest. Comes December 31st, simple interest, you'd owe 110, right?
Correct.
right? So that, but you don't pay on December 31st. So now, and you owe 110 on December 31st. Comes January, February, March, you're in default. The rate now becomes 25%. 25% of what? It should be 25% of 110, shouldn't it? And isn't that exactly
That's
what
not
this
what it
means?
says.
And that's not, it is what it says.
It says,
Not any amounts owing per sections to sections 1 and 3A. December 31st,
As
you owed
well.
110.
as well as any amounts owing pursuant to Section 1,
Exactly,
which is
the
the amount
10.
that's accruing.
The 10 that you owed for the fact that you had the 100 for the year.
I believe that the statutes, the two provisions, get you into the
I ask you
default
this
rate.
not to give you a tough question, which I don't think you were expecting exactly, but just I'm trying to understand it myself, how this works and how it works consistently.
They run
like this.
concurrently after a default.
What about the invoices that showed what they were charging, the 25%?
We don't deny that they weren't charging that, but the cases and the law is, the note says otherwise, right? They have a right to do it. Because they don't choose to do it, doesn't make the loan void ab initio for criminal usury.
So counsel said that it was the defendant that drafted that language in the note.
Now, I don't know if that's in the record, and I'm not aware of that.
Okay.
Thank you. Thank you all.
Thank you.